Hello, I'm David DeWolf, and I'm a candidate for position 1 on the state Supreme Court. This is the fourth of 4 videos that explain what is at stake in this election. A choice between a court that respects your rights and one that has replaced your rights with its own idea of how you should live. This video describes the drastic steps the court has threatened to take, putting our state at risk rather than admitting that it made a mistake in its McCleary decision. In the previous 3 videos, I described how our state constitution commits our state government to the protection and maintenance of individual rights, and how the court's McCleary decision turns those rights upside down, claiming to find a positive right to an amply funded education that would convert our Constitution from a leash that restrains government into a cattle prod that can force us to do whatever it thinks is best. The trial court in McCleary found that the state hadn't fulfilled its duty to make ample provision for education, but it didn't specify the remedy. Neither did the Washington Supreme Court. Logic tells us there are 2 ways the legislature and the governor could fix what the court thought was wrong in McCleary, not enough money for education. One way would be to take money from some other item or items in the budget. The second alternative would be to raise taxes. The previous videos demonstrated that the court's authority is not rooted in the Constitution. But another reason to question their judgment is the inability to resolve the case in an orderly way. This case began in 2007, and here it is 2016, and we're still wondering what is going to happen. In an ordinary case, after the trial court reaches a decision and the appellate courts consider an appeal, the decision from the Supreme Court affirming the trial court would result in the trial court carrying out the judgment. But that didn't happen in this case. The Supreme Court retained jurisdiction over the case and ordered the state to prove to the court that it was obeying the order imposed by the trial court. When the next legislative session didn't satisfy the court, a hearing was scheduled to consider whether to hold the state in contempt. And in doing so, the court listed a series of sanctions that it wanted the state to address in the hearing. Even though none of them would actually achieve the ostensible goal of the plaintiffs to provide more money for education, these remedies are consistent with a view of the state as though it were a deadbeat dad. After all, if you order the deadbeat dad to serve time in jail for contempt, he won't be earning any money. But by threatening that sort of punishment and being willing to follow through on it, the court might motivate the deadbeat dad to go out and get a job and pay his child support. So it makes a certain amount of sense for a court to order something apparently destructive, like putting the deadbeat dad in jail, in order to achieve compliance. Again, it's hard to believe that the court paid so little attention to the dramatic difference between dealing with the state and dealing with the deadbeat dad. You should ask yourself, was the court serious about possibly cutting off all funding to the school children of Washington? I really don't know the answer to that question. Perhaps the court wasn't serious. Perhaps they just listed these sanctions to scare the legislature and the governor. On the other hand, maybe they actually believed that the principle in this case was so important that it would be worth closing the schools in Washington just to prove a point. After all, the Superintendent of Public Instruction recently filed an amicus brief proposing that the court consider taking just such a step. But in one sense, it doesn't matter whether the court was serious or not. If the Washington Supreme Court wasn't serious, if it just used these threats in the hope that the legislature and the governor would agree to raise taxes or shift money from one budget priority to another, then they have misused the power of the Supreme Court in clear violation of the oath they took to uphold the Constitution. On the other hand, if they thought that enforcing the Constitution meant they should cut off funding to the schools just to prove a point, if that was necessary, then we're in even worse shape. Whichever alternative it turns out to be, we're in desperate need of a course correction on our state Supreme Court. If you have stayed with me through the length of this video, I appreciate your attention. I hope it has made clear why I'm a candidate to serve on the Washington Supreme Court. I encourage you to read more closely the documents I have referenced in the course of this video series to see for yourself why I chose to run. I urge you to become active in the campaign to return our Supreme Court to its proper role in our constitutional form of government. Our Constitution gives the Supreme Court the last word on what our Constitution means and how it applies to protect our rights. But it gives the voters the last word on who sits on the Supreme Court. If the current members of the Supreme Court have not been faithful stewards of our constitutional rights, then we should not re-elect them. I hope you've enjoyed this video series. If you have any questions or comments about it, please feel free to contact me through the links on my website, DeWolfforjustice.org. I'm David DeWolf. Thanks for watching.